Hi folks, this is Hector Agostini from Middlesex Community College, and this is for my business law students. Chapter 13, guys. Let's hit that. You're going to find this chapter very interesting, I hope, as well as very necessary in your personal lives. It deals with credit and bankruptcies and a few other things. So let's go on over to page 277. On page 277, we talk about credit, secured and unsecured. Credit is when someone allows you to pay later on. It could be that the person is giving you a loan, you pay the loan back later, or you buy some property like a car and allows you to pay later on. The person, as I show you on page 277, that owes the money, that owes the debtor, borrower, and the person who lends the money or gives the credit out is called a creditor. Now, we have two types of credit, secured and unsecured. Secured basically means that you have a piece of property acting as collateral, sort of guarantee for repayment of the loan. You don't pay the loan, they take that piece of property away from you. Unsecured is a little bit different. Unsecured, you're giving a promise that you will pay. If you don't pay, well, they're going to have to take you to court. There's nothing specifically in your property that they can take. The court enforces a judgment against you if they find that you owe the money, and then you are bound to pay. However, they just can't come and grab property. Now, over on page 279, we talk about real estate. We talked about that briefly a little while ago. You buy a piece of real estate, a mortgage secures the loan. The person that gives the mortgage is going to be you, the buyer. You will be the mortgagor. The mortgagee would be the bank that lends you the money. What happens if you don't pay? The bank will foreclose on your property. They have a lien, L-I-E-N, against your property. If you don't pay, they foreclose, which means they take action to take the house away from you. The house will then be sold, more than likely at auction. And then if you still owe money, you will have what is called a deficiency. The bank can still go after you for the deficiency if they want to. So you have to make sure that if you can't afford the house, don't take it, because even if they take the house away from you, there might be a deficiency against you, and that's additional money you will have to pay. By the way, it's also possible that you may end up in a taxable situation. If you borrow money and don't pay it back, that might be considered as income, and you will have to pay income tax on it. That is another nightmare for another class. Anyway, at the bottom of page 279, they talk about a note and a deed of trust. I'm not going to get into that. It's pretty self-explanatory there. Anyway, let's go on over to page 280. In many jurisdictions, the recording of the lien against the house or the deed itself are very, very important. If you don't record, it's quite possible that you could end up losing your property. So if you're in a recording state in particular, and most of them are, make sure you get your deed recorded. Now, we talked about deficiency. We're not going to get into that. Now, secured transactions and personal property. Now, property, as I mentioned before, breaks down into two types. Real property, real estate, and personal property, sometimes called chattel. Personal property can be moved around. Real estate cannot be moved around. And they're pretty much the same as we've talked about before. So over on page 283, you can see the basic relationship between the buyer, the seller, and the lender, the borrower, the debtor. Okay? Now, when you buy a piece of property, such as a car or a piece of equipment for your business, like a tow truck, a forklift, or something like that, what the lender will often do, the creditor will often do, is have what is called a secured interest in that piece of property. If you don't pay, they will take that property away from you. And to let everybody else know that that property is compromised, that it is leaned against by another creditor, the creditor will often record this at local city hall or county hall to place everybody on notice that this property is compromised, that if anyone lends you money on that particular property, that person will come second. Same thing really is sort of the same thing with real estate. Now, that comes down to on page 284, the security agreement, and that's what really secures or guarantees that you will pay to the creditor. All right. As far as security interests go, it's a fairly complicated area. It's under Section 9 of the UCC. Leave it alone. All right. Now, priority of claims over on 287. Sometimes you will have two or more creditors you owe money to. Generally speaking, the first one to lend you the money is going to be the first creditor. A subsequent creditor will take a secondary position. What does that mean? Well, whoever's got a primary position goes first after your property. If there's any money left over, then the second creditor, third creditor, fourth creditor will then get whatever's left over. Sometimes in order to get a loan, you will have to get a first primary creditor to be willing to subordinate. To subordinate means the primary creditor will take a secondary position to a subsequent creditor. Very hard to do, but sometimes it has been done. Okay? Now, let's get into sureties and guarantee arrangement. Whenever you have a friend, a family member, and this you should not do, no matter how close you are to the person, unless it's your mother or your father, that might be different, or your son, or your daughter. But surety agreements, guarantee agreements. In a surety agreement, basically, you're accepting responsibility for the loan that the debtor takes on. They can go after you, or they can go after the debtor. Okay? The creditor has a choice at that point. In a guarantee arrangement, it's a slightly different arrangement. In a guarantee arrangement, if the debtor doesn't pay, then they will go after you. You're basically the secondary person that they can go after for money. So if you ever guarantee a loan and the primary person borrowing the money doesn't pay, they will come after you. All right? So just be very, very careful about signing for anybody, co-signing for anybody. Make sure that you protect yourself. I recommend you never co-sign for anybody unless it's absolutely necessary, and that you have some sort of guarantees that you'll get your money back. Bankruptcy. Right now, I'm sure there are a lot of people thinking about bankruptcy, a lot of firms thinking about bankruptcies. I'm going to cover two basic types: the personal bankruptcy and the business bankruptcy. Now, the basis of all bankruptcies is basically Chapter 7. Chapter 7 is called a liquidation bankruptcy, and this is at the bottom of page 289. And in a bankruptcy, Chapter 7, you're supposed to liquidate all your assets. What does that mean, liquidate? Well, it means to sell off all your property, convert it all to cash, and pay off all the creditors. But there's a slight difference between the personal bankruptcy and the business bankruptcy. In a business bankruptcy, well, we'll cover that in a few minutes, but in a personal bankruptcy, what happens is they allow you to have certain exemptions, certain amount of money, certain amount of clothing. You could reaffirm the debt. Let's say you have a house, and the bank is coming after the house. You could reaffirm the debt to the bank to allow you to stay in the house. But again, you've got to be careful about reaffirming a debt. What it basically means when you reaffirm a debt is that you're accepting it even though the bankruptcy court allows you or will allow you to get out of it. But I'll talk about that more in a few minutes. Now, we talked about the two types of bankruptcies, the personal and the business. The personal bankruptcy, you have Chapter 7, Chapter 13. 7, as I mentioned a minute ago, full liquidation. You list all your property, all the assets you have, you list all the debts you have. The bankruptcy court will turn over to secured creditors any property that is secured. The others will go into a pool. All your property is then sold off, except the exemptions that you happen to have. And then, of course, the money that is raised from selling your property will then be distributed among your creditors. It won't be dollar for dollar as a rule. It rarely is. It might be pennies on the dollars for the creditors, but that's life. At that point, your debts will be discharged. When your debts are discharged, it means you don't owe anybody anything, except if you reaffirm a debt. Again, get a lawyer. Be very careful of anyone who wants you to reaffirm a debt. All right. Now, Chapter 13. Chapter 13 basically means it's a workout situation. And in 13, what happens is that you want to pay your debts. You have some capability to pay your debts. but you can't pay all your debts. What happens there is that the bankruptcy courts, and by the way, the bankruptcy courts are run by the federal government. There are no state bankruptcy courts. They're all under the federal system. Anyway, what happens there in a Chapter 13, all your debts are listed. A workout plan is put together. Now, it is a fairly complicated step. You should get an attorney for this for sure. But in a workout situation, what happens is your creditors might be paid 40, 50 cents on the dollar based upon your property. Any secured creditors, as a rule, can take your property away, that property away from you. But again, it all depends upon the bankruptcy court. Now, what happens if you can't pay and you haven't filed bankruptcy yet? Well, you got a problem because the creditors are going to come after you. So let's go on over to page 291, the automatic stay. The minute you file bankruptcy, there is an automatic stay. The stay basically means everything is frozen in place. The creditors cannot come after you. They cannot take your property away from you unless they get approval from the court. And for that to happen, the bankruptcy's got to be filed at the court. The court then decides whether it's going to be a Chapter 7 or 13. It depends upon you what you want to do. Many people will prefer to do the 7 because they're so deep in debt. But sometimes you might be able to do a workout situation, which is a little bit better for you. Everything must be approved by the courts. Once the workout session in Chapter 13 is approved by the courts, everybody must agree to that, okay, to accept what he or she receives. Now, for business bankruptcies, and again, we talked about personal bankruptcies over on page 293 and 295. But the business bankruptcy is quite similar, except here we have a Chapter 7, which is total liquidation, and we have a Chapter 11. Now, Chapter 11 sometimes is called reorganization. It's a personal workout situation, so to speak, for the business. All the creditors of the business are listed, a workout plan is put together, and the company stays in business. The creditors cannot come in and start taking stuff. They cannot take the company to court. Why? Because they have the automatic stay. The stay, again, freezes everything, and the creditors have to wait until the bankruptcy court makes a decision. Once in a while, the bankruptcy court might say, there's really no way for this business to stay alive. It should go into Chapter 7. So it'll be forced back into Chapter 7, which is total liquidation. We don't want that. Now, what happens if you've got some property you want to hang on to and you don't want to let the courts know about it? Two things. If you don't let the courts know how much debt you have as well as how much you owe, that is considered fraud. If you transfer property to a friend, a family member, without the court's permission, that's fraud. Fraudulent transfer. Don't do that. You can go to jail. And then finally, let's wrap up with what your homework's going to be. Your homework's going to be case number 2. All right? So if you have any problems, email me. Let me know. Again, I want to thank Mr. Gendre, Dr. Gendre, for being so kind and gracious to have such a beautiful office for me to record this. I'm going to have to take him to lunch pretty soon, I guess, when the restaurant's open. Keep well, keep safe. Remember, family and friends first. Bye now.